Call roll. Oh, I'm sorry. Invocation. Let's do invocation first. Melvina, would you please?
Erode velante he ikan leja fikati no de dosa heli de les nega de hit kadidan to ahando duda agosti se kaneli se galosi do han not the down program Leona the jutne ke has fire chi kana e cases ne de jadna na jan ke has no dana no the gospel ne has obi le dance de don oji yawo ahan ojo ja fa bego violence ni ahanelo oji tirisa uses ojdan tehesta. Father, we just thank you for this day, for this beautiful day that you've sent us. We just ask you to be with each and every one as we go about our business. Lord, there's not a thing that you don't know. You know the heart and the mind of every individual in this room. Lord, I just ask that we don't do things the way we see it, but pleasing to thy eyes. Yes. Lord, forgive us as our shortcomings. We're humans. We err. You're the only perfect, and glad to know a man like you. Yes. Thank you, Jesus, for your loving kindness. I just ask that you be in this meeting, not today, but the days to come. In your name I pray. Amen.
Amen.
Roll call.
Linda O'Leary.
Present.
Bill John Baker.
Here.
Bill Anglin.
Here.
Jack Baker.
Here.
Audra Connor. Joe Crittenden.
Here.
Meredith Fraley. Here. Don Garvin. Chuck Hoskins. Bill Johnson.
Here.
Taylor Keene. John Keener. Jackie Ball Martin. Melvina Shothouse. David Thornton.
Present.
Carol Cowan Watts. Phyllis Yardy.
Okay, we have quorum. We'll continue. The first item is a request for additional appropriation for FY 2007 for litigation. Administration is asking for $520,000. Who's going to present that? Melanie?
Good afternoon.
How are you?
I'm fine. How are you?
Good.
Back in the ENF meeting last, I made a request for an additional $520,000 for us to defend the constitutional amendment that we had by way of special election on March 3rd. During that meeting, it was requested that I prepare a report, which I've given to you, that shows what we've spent on external attorney fees since the beginning of the case. As I said in the ENF committee, when we prepared the budget for this year, we did not know, and in fact we had moved that the case be dismissed because we thought the nation should be an indispensable party and that we couldn't be joined because of sovereign immunity. The court disagreed with us in December. They allowed that the plaintiffs could amend the complaint to add the nation as a party and add the officials as parties to the case. So that happened shortly after in January. So what you see here are costs that extend since the suit was initially filed in 2003.
Second, ma'am.
Yes.
Bill John.
Am I reading this right? That a lot of it started in 03,
Yes.
and I assume that's already been paid.
Yes.
And then a bunch of it, or some of it's in 04, and then a lot of it in 05.
Right.
I assume that's been paid.
Mm-hmm.
And all of the 06 has been paid.
Very likely, yes.
So, and you paid out a considerable sum.
That's right.
So I guess my question is what pot of money do you have that you could use to pay for this lawsuit?
Pay what we've incurred thus far?
Well, I mean, you've already paid all except $40,000 or $100,000, correct?
I'm not sure if we've paid. I know that we haven't paid the last invoice that's shown on this. That's dated 4/2. Because we just received it.
Right, and
I'm not sure if we've paid the invoice right directly before that yet.
Okay. So
But what I want to say is
so
that...
$80,000.
Right, approximately. Where we're paying for that currently is the litigation account that you all have appropriated. It's just one fund that funds all of our litigation activities, and that includes Arkansas Riverbed, any other litigation.
And my question is,
Yes.
what is the funding level of that pool of money?
I'll have to ask the AG that question. The total litigation account?
Let me, right now, before we got those last two, I think when I had my assistant check on it, it was right around $200,000 before that last bill came in. Let me call and I'll get the figure exactly,
Okay.
if I can do that.
So we're thinking maybe there's 100,000 left. I mean,
Approximately.
she's checking. I guess my question is, do you anticipate it costing $600,000?
It may not cost $520,000. This last couple of months of billing, I think, is more indicative of the costs we're going to see now that we're a full party to the case. So what I wanted to mention is that we've had costs since the suit was first filed, but we've had various stages of it, obviously. The first stage is when we moved to intervene on a limited basis, and that happened in December of '04, and you all ratified that decision in March of '05. So you'll see that there were some higher levels of costs that followed that because we moved to intervene on a limited basis. We prepared those filings and made them. Following the December 9th decision that added us as a party, the importance of that is that it not only adds us in the officials as parties, but it waived our sovereign immunity effectively. So any decision that comes out of this case is binding on the nation. What we did was we immediately appealed some of those decisions, and Diane can get into that when she gets back in the room. So some of those appeals are already sitting at the appellate level while we're still working on the case that's in the D.C. district. So while the main case is still in D.C. district, we're appealing some of these decisions as that goes on in the appellate court. So we really have more than one case that gets associated with the same case because we're in the appellate court and we're in the D.C. district. So that's why we anticipate a significant rise in costs based on not only being a party, but then also appealing decisions as we go.
Yes.
Madam Chair, I move that we approve this. Second.
I have a motion, I have a second. Further discussion? Yes.
I haven't got all the information back yet. Todd, if I could ask you, to protect the nation, do you think this is a reasonable request at this time?
Yes, to protect it. You're going to need attorneys, okay? I know that the Cherokee Nation has attorneys on staff. But we're fighting in a Washington, D. forum, a highly specialized area, and I do believe that you're going to need Washington, D.C. attorneys, and they cost a lot more than we do down in Greasy, Oklahoma.
Your bank?
Yeah, a little bit. And I take it that this $520,000 will go into the litigation cost center, correct? And you're going to be paying all your litigation out of it, but you expect the $500,000 to cover the estimated cost for the remainder of the life of this lawsuit. Is that correct?
Well, we're requesting it for this fiscal year.
Right.
Obviously, if we don't spend it, we're not going to spend it unless we have to.
Right, yeah. But there are other outside counsel that you would be paying out of the same bucket.
Possibly,
correct?
yes.
Although $500,000 is an immense amount of money, it's foreseeable that a case like this that could go to the United States Supreme Court would cost that much.
I just wanted to add, Madam Chair, that because of the nature of the case, we haven't gotten into the merits of the case yet that deals with the 1866 treaty and what the nation is required to do based on the 1866 treaty and all the things associated with that. But because it involves so much of our history and that we know best our history, we are going to utilize our own staff as much as possible to try to minimize the costs.
Yeah. Did you get the answer, Diane?
No, sir, I did not. Mr. Evans is getting it.
Yeah.
Okay.
Running now.
So at this point, you're anticipating active lawsuit, $100,000 a month cost.
Well, we have about 7 months left in the fiscal year, so...
You're asking for 5, and we're assuming she's got 100, and you just spent 100. So, I mean, is that what you're anticipating? $100,000 a month?
Roughly so. If that's at maximum. We obviously don't want to have to come back to you for additional money, so we hope it's much less than that.
Okay. Doug, did you find the answer?
Yeah, the budget for this year is $500,000. They've spent $120,000, and there's $364 left on a contract.
Okay, so that being said, are you still asking for 520? I mean, you thought you had 100, now you got 320.
I think what we would have to reconcile is what we've got in the payment process, because I think we've got some invoices in the payment process.
That must be true, because before we requested, I asked for that number, and I recall it being right around 200,000. She's not at her desk, I couldn't get her. And that was before we got the 65,000 in.
This is what's in lawsuit.
That means it's already out the door.
If there's an invoice that hasn't been
But I'm sitting here looking at the numbers, and in the last, since '03, less than $250,000 has been spent on this lawsuit. Well, you had 500 the first of the year, so if you paid all of it, you ought to have 250 left.
Well, this isn't the only case we've got in litigation, sir.
I thought this was all outside attorney fees.
Well,
That's
this
correct,
is,
Mr. Baker.
but it's
I'm
only for
sorry.
this case.
Talking on top of you. There's also the UKB litigation that we didn't anticipate we were going to lose at the circuit level, so that's going to cost more than what we anticipated. The Delaware case is still out there.
So those are not on this report?
They are not. No, all that was asked for is what we spent on the van litigation, and that's what I provided today.
So there's just one litigation budget, and it's down to whatever it is.
320.
360.
360.
364.
360, I do believe there are invoices outstanding, or else.
Say again?
I do believe there are invoices that are in the hopper.
Yeah, that wasn't the number that I got before we requested the money. Whatever the number is left in that budget, that's going to have to cover all those other outside attorney fees also. Because this case is heated up at the rate to the extent it has, that's why we requested this additional amount to cover that. As you can see, the February billing on this case was $65,000. I don't know if every month is going to be like that, but when I made the estimate, we took the biggest months and then just extrapolated from there. That's how we arrived at the number. Obviously, if we don't need all that, we won't spend it. And I'm hoping to have as many issues resolved as we can in the tribal courts, and we'll handle the cases in the tribal courts. So.
Todd, you had a comment?
Oh, I was just going to say, it's litigation like this will be in cycles, okay? Obviously, we've had some months that we've hardly expended any money on this. I do expect in the months to come that you'll be paying your attorneys up there. They'll be doing a lot of billable hours. So I think in the next 3 months or so, you're going to see a very large spike in the litigation as to this, because I predict that there's going to be some type of injunction filed that we're going to have to defend, and that will get into the merits of the case to a certain extent, and that's going to take a lot of manpower. People power, excuse me.
Taylor.
Thank you, Madam Chair. I don't know if this is a question for Secretary of State or the AG, maybe for both, but it's been outspoken on this issue, but I know that I'm not the only one who feels this way. And I guess I have to ask from a personal perspective, because I'm a citizen of this nation as well. I think everything that we did about the special election was forced. I think it was rushed. We did not do a good job educating on both sides of the issue. If we would have slowed down and looked at this issue, we might have foreseen that this kind of action was going to happen now, where we're truly trying to fight for our sovereignty, not just for us, but for other tribes, on the ability to determine our own tribal membership. And I'm very frustrated at the fact that now, it's $500,000 here, and it could be millions of dollars before the end that we're spending those tribal dollars that could be going somewhere else, back to services. And I've been in several pinches in my life, and I had somebody wise once tell me that the best way to get out of a hole is stop digging. We throwing a whole bunch of money here to buy something that's going to get us further into a hole. To me, there's other solutions. But how far are we going to go with this? How many times is going to come back and ask us for money? I guess my first question is, for those of us who think that disenfranchising citizens is wrong, how are these dollars going to defend my position? Are we only fighting? This is the ban litigation, so we're obviously attacking those people who are still citizens of this nation. How can we take tribal dollars to attack their lawyer? I got several questions there, but...
Madam Chair, may I address it? Respectfully, this litigation began well before the special election or even the petition was started. This litigation started in 2003 and primarily about citizenship, but also objecting to our election and wanting to overturn our election. Those are basic fundamental processes under our Constitution. I feel it's my duty to protect those fundamental processes under our Constitution. Further, our court later decided that they should be added as citizens, that they have been rightfully so citizens, and we began enrolling them as citizens. The case continued. The case continued after our highest court made that decision. We were joined as a party, and our officials were joined as parties prior to the special election. So I do not know, and I don't think I can say that this case would not be there had it not been for the special election. And maybe Diane can speak to that more closely than I can, but the case has been there. We were joined as a party in December, and all of that happened prior to the special election. So we may have found ourselves, I guess in short, we may have found ourselves in the same place even if there hadn't been a special election.
It certainly did exasperate the situation. The attorneys for the BIA and Justice Kennedy, some of their preliminary injunctions said that if we do vote to disenfranchise, that there will be ramifications.
The attorneys for the government didn't say that.
The attorneys for the BIA did. Said that they would review the trust ramifications.
Well, they were reviewing it from their perspective, whether they had a trust responsibility to anyone. That's the way I read their brief. But Judge Kennedy obviously has his opinions. He ruled on several things that weren't even before him in court in terms of the merits. And the nation rightfully should have the opportunity to present the case on the merits and defend itself before those kinds of decisions are made, in my opinion. But while it may have advanced things more quickly, I guess that's debatable. But this case was there, and we were joined as a party before the election. So, and getting to the election was a result of a petition process. I mean, we could all argue that it should have gone slower or faster, but it was a petition by the people. It was determined to be valid by our courts, and the people voted, and 77% of them voted yes. And so I feel it's my duty. I just be very down to earth with you all. I took the same oath that you did, and so I feel the responsibility that, in that sense, not being elected, but taking the same oath, I do feel the responsibility to uphold our constitutional processes, whatever the outcome of them.
Does that not include protecting the rights of all citizens?
It does. It does.
So we find ourselves in the same conundrum.
I find myself in an interesting conundrum because if say, the federal government, whenever I'll give you an example. When our Supreme Court decided that freedmen were citizens, and we began enrolling them, the federal government fought us on serving them as all other Cherokee citizens. And I found myself in an interesting position because I was fighting the federal government that, yes, they are citizens and they're to be treated on an equal basis. So I think that's right, that, we do have to defend our citizens, but we also have to defend what our citizens' organic document is, and that's the Constitution. That's the ultimate voice of the people. So I guess that's what I have to say about that. I appreciate your concerns.
When I began the question, I didn't also ask the Attorney General, who wasn't in the room, if you have an opinion on that.
What's that, Mr. King?
I'm sorry, I'll go back to the question again. I'm in a difficult position that, beginning with the moral basis, that the continual fight against freedmen citizens has been long going here. And I've been disappointed publicly in the process for how they are becoming disenfranchised. So here we are today. I'm not the only one. I'm often the only one to open my mouth and say it. But that here we find ourselves in a position for asking for a large sum of money that could be going elsewhere, preferably for human services. And we're engaging in further battles with big lawyers in Washington, D.C. And I can't help but look at this and say we are fighting our own citizens in a sense with this. So I'm asking for clarification of, help me and others figure out. We certainly want to support the nation as a whole. However, in this case, all this documentation says ban litigation, and this refers directly to the freedom situation. You are still citizens.
No, sir, they're not.
They've all been disenrolled.
Yes, they've all received the letter. Now, some of them may be still receiving services. They had a 90-day window for services and a 90-day period in which they could appeal, but they received, the letter went out notifying them that they were no longer citizens. After the 10-day appeal process that immediately followed the election, where the election itself could have been challenged. So immediately after that, then the letter went out.
They were citizens.
Yes, they were.
And this is making sure that they're not at any point in the future. And I have a problem with that.
I understand that, and I think that I'm the only one, I hope, that has publicly said what my vote was going to be. I told Judge Kennedy what it was going to be because I thought it was important in the argument, and I think everyone knows. I went on record as saying I was going to vote no, and in fact I did. I have some of the same internal conflict that you do. But we're not talking about whether or not they should be citizens, whether the vote should have gone the way it did. What we're talking about is defending the nation in a lawsuit that the nation did not bring against an attack upon its government and now an attack upon its processes. The initiative petition went through the process, went through the courts. So it's actually, the way I look at it, is I'm defending the nation's government and the people's right to decide. I might not agree with what they decided, but it's my job to defend that decision if it followed the law, and the courts found that it has. So to the best of my ability, I'll have to do that. Perhaps in a broader perspective, we heard what the Seminole Attorney General had to say about the fights that they had internally. So the ramifications can be very large. I find it distasteful to have to pay $300 and $500 an hour lawyers in the District of Columbia also. But the reality is we just have to. We have the circuit case going on Judge Kennedy's decision in December, and then we still have the district court case going on in front of him right now. Nothing has been filed other than an extension of time, but we don't know when that's going to change. I don't know that that's been helpful at all, but that's the way I look at it.
Go ahead, I'm sorry.
Question. What is our intent for this litigation?
My intent is to zealously defend the nation, and I hope at some point that we can have the issue in front of our court to decide it once and for all, what that 1866 treaty meant. Did it mean that these people and their descendants...
I thought we already did.
No, sir, we haven't. Not in our courts. What they held in, if you're talking about the Allen decision, what they held in Allen was that our constitutional language in the 75 and the 99 Constitution, they're the same, was ambiguous, that it did not clearly specify who was to be included and who was to be excluded. That if we were going to exclude them, we better be darn specific about it. And then the initiative followed that. And again,
I'm confused on that point because I mean, this was the trigger point that exacerbated this whole situation, including the litigation. After that ruling came the famous speech of, 3 people have changed the course of history. To me, I'm not a lawyer, but to me, that case said that their citizenship had not been erased and that overturned a previous court ruling.
Overturned the Rick's decision, found that the Constitution did not specifically exclude them, didn't say by blood, didn't specifically delineate, so that they were in fact included. And the registration statute that excluded them was unconstitutional. They were immediately made citizens. Shortly thereafter, the initiative process began to specifically change the Constitution. So, as far as what the 1866...
But again, I go back to my point. But once they were ruled as citizens, that was our highest court.
It was.
But you're saying you don't agree with
No,
that?
no, I'm not at all. The court said they're citizens, and they were, and we treated them like citizens, and we defended their citizenship. Then the initiative started to change the Constitution, so it would specifically exclude them, and that has happened. Our court has never ruled on what that 1866 treaty provision meant. Did it mean that the freedmen and their descendants were entitled to permanent citizenship within the Cherokee Nation? And intelligent people can differ on that, and they can argue on that, and we can extrapolate. Does that mean that any of us are entitled to eternal citizenship, or can we impose a blood quantum at some point? I mean, those are all difficult questions. So, you asked me what I hope to finally resolve. What I hope to finally resolve is to finally get closure on it.
What might that be?
I would like for our courts here in the Cherokee Nation to decide that, and that's what I've been arguing in the District of Columbia. This case should not be in the District of Columbia, it should be in the Cherokee Nation court system.
So the intent of the litigation then is to defeat the federal litigation?
I guess, yes. It would be my intent to get it out of the District of Columbia and back to the Cherokee Nation. I think that's where it ought to be. And also, when we've talked about this in depth, just as a separate point, what Judge Kennedy did, I mean, don't even think about the freedmen, was about expanding when sovereign immunity is waived, and found that it was congressional intent when there was no clear language that said that. I think that is an aberration of law that needs to be corrected if we're talking about freedmen or contracts or torts or whatever we're talking about, because that's dangerous to find a waiver of sovereign immunity where it wasn't explicitly stated.
Okay, so the overall intent here is not to cement and ensure the fact that Cherokee freedmen will not be citizens again.
My intent is to defend the lawsuit. And personally, I would like for it to be resolved on the merits in the Cherokee Nation court system so that we can get to closure.
Thank you. Thank you, Madam Chair.
Thank you. David?
Maybe I usually look at this a little different than everybody else. But the way that I feel about these Washington lawyers, I don't trust them. I think they'll keep this case going and fighting just as long as they can because they know that the game is money. I would rather have our people fighting right out here, across the road over here at the administration. If we can't have those people fighting it, I'm sure there's good Cherokee lawyers that could fight that battle for us. And they would have a dog in the fight when you see something like that. Because of their heritage, their background. That's the way I feel about it. I'm not for giving this $500-something thousand to keep this fight up there. I think we can do it here. I think we've got an office in D.C. If we can work out up there, we spend $500,000 or close to it for people up there in an office every year. I don't know why our own people can't go up there and fight this battle. That's the way I feel about it. Thank you.
I have a question too on the judicial justices. First said the freedmen are citizens. Okay, we recognize that. We all know that. And then next we have the petition that follows with a lot of controversy on whether or not that's even correct, but our new justices recognize that. And that's where that stems from, that we're in this situation now. Where does that put us with our sovereignty immunity for this council to vote for something like this in fighting our own citizens and being subject to possibly our own federal dollars being taken away from us? Are you foreseeing that the federal government or the BIA will not step in at some point in time?
They're in the lawsuit in Van versus Kempthorne. They are in the lawsuit. They were a party before we were a party. Whether or not we want to be there, we're there. And we have to defend it. And I wish that we didn't have to pay expensive lawyers in the District of Columbia to adequately fight, but we do. And as you know, I did the argument the last time. I will do the best I can to use my people all I can and guard the lawsuit and keep tabs on it. The reality of the matter is just that we have to have those District of Columbia attorneys to fight in the District of Columbia.
Tom, do you have a comment?
No. Nothing specific. It's that as I stated earlier, and Ms. Hammond's just repeated, this is the forum that we're in, like it or not. We thought we could do a motion to dismiss because we were an indispensable party. Well, the judge ruled, yeah, we're indispensable, and yeah, you can be joined. And I think what's important about this lawsuit at this stage of the game, as to me, is defending our Constitution and defending sovereign immunity. Ms. Hammonds is right. The legal theory put forward by the judge can be scary, because if anything, the main tenet of sovereign immunity is that you have immunity unless there is a clear, explicit, uncontroverted waiver of it. And here we are in a legal decision that he gets a waiver of sovereign immunity without a clear, unmistakable, uncontroverted waiver of it. Correct? And that's what makes the case that much that important as to not only the Cherokee Nation but other Indian nations throughout the country. And that whether the merits of the case, they are difficult, they are morally perplexing, and reasonable people are going to have different views on that. To me, it's an issue of constitutionality and sovereign immunity, and And if you're going, we're up there, and you're going to have to get highly specialized attorneys that are used to that form. And although $500,000 is a lot of money, and we put a lot of water into people's houses and other great services, this is going to be, in my opinion, a necessary.
Then the next question is, what's the outcome of that? If this council votes for that $520,000, we don't even know what the amount is needed. I don't like to vote on something not knowing how much money is needed there and how much is in the pond, so to speak. But isn't that also going to open us up for litigation from the freedmen to also sue the Cherokee Nation and every one of us council members again when we're fighting our own citizens?
Well, I mean, anybody with a filing fee can file a lawsuit.
And is that not challenge our sovereignty based on that alone?
Yeah, and
I mean, we're in a catch-22, right?
No, I don't think you're in a catch-22.
Well, then explain it to me.
Okay. You have the ability either to fund the lawsuit or not. Okay. Much analogous to Congress right now in the Iraq War. Okay. They could choose not to fund that war, and which would, mean unmistakably we would have to withdraw from that. You could choose not to fund this lawsuit, which would mean unmistakably we would lose this lawsuit. Now, the ramifications of us losing that lawsuit to the government as a whole, I think, would be unmistakably bad if we were to lose the lawsuit, because it would attack our sovereignty and would totally throw out a constitution that the majority of the people voted to approve in 2003.
Taylor, do you have a question?
Todd, for Diana.
Almost got
I have a hard time understanding that we have to pony up to, get Ryan Snosky and fight this battle. I mean, it's my understanding that Freeman's lawyer's out of Oklahoma City.
Is.
Correct?
Is. Well, Mr. Bealey's out of Oklahoma City, Mr. Dunn's out of the District of Columbia.
Okay. But we have to, I know they don't have a big money machine, certainly, to do this. To me, this seems like a movement to just trump them with money. We're going to win this by sheer money if need be. When we have, obviously, a lot of capable...
We do. None of us are licensed in the District of Columbia. I'm seeking licensure in the Circuit Court of the District of Columbia. But I don't have the ability to fight. I don't have the ability to fight effectively in that district. I just don't. There's not a whole lot of money on the other side, although I think special interest groups contribute to the attorney fees. I don't know, but that's what I've been told. We want to fight the best we can and present the best case we can because of the downside. The downside is so big, not only as to sovereign immunity, but as to the threat against our seated government and possibly to federal funding. Those are big downsides. It is a lot of money. There have been a couple of questions about are we paying to fight against our own citizens? There have been, just as an aside, I think now there are approximately 100 registration appeals filed in the district courts of the Cherokee Nation. I'm going to file today a motion on some other technical grounds, but also asking the court to appoint counsel for those people who have already filed, because I think that's very important. The court has a court fund to pay for attorney fees, and they may very well have to come back and ask for more for that too. But I think it's important that those petitioners receive the absolute best representation they can receive also.
Thank you.
And then Kara.
And we had loads from around this area that were Cherokee lawyers that went to Washington, D.C. and fought battles for us before.
Oh, absolutely. Yeah. They're very capable Cherokee attorneys. I hope I'm one of them.
Do you think you
I say, I hope I'm one of them.
You're one of them?
Yeah, I'm one of them. That's all from South Greasy. Thank you.
Kara?
Thank you. I'm concerned about some of the remarks that, we took an oath of office to uphold the Constitution and the people's right to decide and those kind of things, which all are involved in this position. And one of the earlier remarks was that this other side doesn't necessarily have money. Well, I don't have full proof, but it only took me about 30 minutes on Google to find out who's funding them. And it's a huge nonprofit group with a large, extensive network of lawyers that is funding them out of D.C. So I take this as a very serious commitment to fight for our sovereignty and the people's right to decide our citizenship. And it's going to take the $500,000 and the D.C. law firm that we've used that's proven themselves in front of the Supreme Court for us on other occasions. So this is not something to be taken lightly, and I think we have an obligation for our oath of office to protect the tribe and not folks that weren't citizens even over a year ago. So this is what the people decided overwhelmingly, and we are here seated to do that. So we need to make a decision today on this. Thank you, Madam Chair.
Joe?
Thank you, Madam Chair. I heard the definition of sovereignty the other day, and I can apply it to me because I'm sort of a country guy. Sovereignty, according to this individual, was merely the best deal you could hammer out with somebody who is more powerful. I think our elders, ancestors, or whatever, had a pretty good situation going. I mean, they signed the Treaty of 1866. I also heard a comment about our oath of office a while ago. I think the oath of office I took was the one to uphold or defend the Constitution of the Cherokee Nation and also the United States. There's a second half to that that sometimes gets left off. I also think that the freedmen descendants were citizens long before a time of a year ago or whenever it was referenced. I even think some of them sat on the council way back. I just have trouble when you got a small group opposing a large group, as it seems like the case is here. I kind of like to go for the underdog in a lot of things, in a sense. So I can't support this $500,000 or whatever we're talking about. I'm sorry. Thank you, Madam Chair.
Thank you. Bill?
Thank you, Madam Chair. Well, I've heard both sides today and everything else too. I have to support this because I took an oath of office to support the Cherokee Nation Constitution that I believe, and I'm a United States citizen also, and I support the United States Constitution also as well. But the oath of office, the people elected me were Cherokee citizens, and I have to do what the Cherokee citizens voted to do. Right or wrong, however anybody wants to twist it, turn it, whatever you want to mix it up, it is just a vote to protect our Cherokee Nation, and that's what I want to do, whatever it takes to do it. And so that's where I stand on it.
Thank you. I have a question of Diane and Melanie, please. The last time we met in here, March the 30th, at our last executive finance meeting, we read into record a letter from Carl Hartman, Secretary of the Interior. Are you ladies familiar with that letter now?
We are, and the chief did receive it in snail mail later.
Snail mail?
Yes, the regular postal service.
Okay. My understanding is also that there has been teleconferences with the attorneys from the BIA, with some of the lawyers there in our administration, and including the chief, and possibly another gentleman in Washington, D.C. And we got no comment back from you all, if that's the case, and I understand it to be the case.
I've had no such conversations. The only conversations I've had with DC attorneys have been regarding the Bath versus Kemthorne. I haven't spoken to anybody at Cherokee.
I really feel sometimes that this council's not getting all the information or a true picture of information, and I want to suggest that we do receive any and all that we ask for, and even in our FOIA request. That's an issue with some of the council here that's came to me, and we will be, in the next turn of events, be producing some legislation on that also. But in the meantime, what I'm concerned about is we don't know exactly what pool of money's there. We don't know exactly, you don't know exactly the filings of the litigation that's going to be coming up, do you, Diane? I mean, isn't this just kind of we think it's going to happen, and this is what we've got to respond to? Can we not initially respond with our own attorneys, and then at a later date, see if we need these added monies?
My attorneys and I can't practice in the District of Columbia. I've been allowed to practice before Judge Kennedy by his permission, so I guess I still could. And we're not out of money. I mean, we were just anticipating, based upon what had happened in the last few months, that we were going to run out.
So basically, if this was tabled even until next month, there's not a problem, is there, as far as we have the money, you have the capabilities with the attorneys and yourself, and seeing what the future holds for us?
I'm not going to run out of money in the next month, no.
Okay.
Madam Chair,
Yes.
may I address the information request that you made to me about meetings, teleconferences, et cetera?
Yes.
I still stand by the truthfulness of that request.
Okay.
If there's anything I don't know about, I probably need to know. But with all the information I have, I responded as truthfully as the information I have. So
I appreciate that. Yes, okay. Go ahead, sir.
Billy wasn't there, but it's bad weather going around right there.
Uh-oh.
And it has something to do with the Arkansas riverbed money
Okay.
that Cherokee Nation asked for a drawdown. It was refused. Have we already gotten all that funded for?
And in fact, we've been drawing it as we've been budgeting it. So for the most part, the most recent drawdown that we've requested was one to pay the final payment on Patton Boggs that you all approved to settle that matter. We sent an initial letter like we did all the other attorney payments, and just like their first payment, and the BI asked for additional information. They asked for a payment request, I think they call it an invoice, and they asked for the settlement agreement. So what I did is I prepared that and sent it to them. Next notice I get is that, well, they wanted Chief's signature on that voucher instead of mine. And they've accepted my signature before on previous drawdowns. We prepared one under the Chief's signature and sent it in. So I think we've responded to every additional request they've made. So they haven't rejected it as far as I know.
Have they paid that?
They've not paid it. The last time we sent something in was last Friday, I believe. So that was the last transmittal.
Okay, thank you.
You're welcome.
Meredith.
This is for either of you. You made the comment that the judge, of course, ruled that we are a party to this litigation, and that's one of the reasons that the costs are higher, because we are now a party. We don't approve this appropriation. Tell me what the consequences are.
Well,
We have our name, the party to this litigation.
when we run out of money, we will have to defend it from Tahlequah. And
You can't practice in the DC court, or
I cannot, except that Judge Kennedy has allowed me to practice. He allowed me to make the argument there. But I agree with Mr. Hembry. If we don't have outside counsel, we will lose. I don't think that's an overstatement.
thank you.
Thank you. Any other comments? Any other discussion?
All the question.
Call for the question. All those in favor? All opposed, same sign? Aye.
Joe England,
Yes. Well, is yes for the appropriation.
Bill John Baker,
Yes.
Jack Baker,
Yes.
Audra Connor, Joe Crittenden,
No.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Chuck Hoskin, Bill Johnson,
Yes.
Taylor King,
No.
John Keener,
No.
Jackie Bob Martin,
Yes.
Linda O'Leary,
No.
Melvin Shophouse,
Yes.
David Thornton, Carol Cowan Watts,
Yes.
Phyllis Yarden. 9 yea, 5 nay.
Motion carries. Moving on to item 2, Treasurer's Report, Cherokee Connect. Callie, is that you?
Good afternoon.
Good afternoon, Callie.
I apologize I wasn't here at the last DNF. I finally took a day off. What I don't have anything really new to report on Connects. I reported at a couple of meetings. You know, we entered into the agreement whereby our minority partners are paying us $2 million. We no longer own an interest in the company. The $2 million was payable in 2 payments. The first one was due March 7th, which we received. The second will be due no later than the end of July. Also, the name of the company will be changed. I believe the name they're going to use is Connects USA, so they will be dropping the name Cherokee.
Bill John?
Yes. If they make the second payment, how much did we lose?
Well, we loaned $4 million to start up Connects. We're going to receive $2 million from the partners' guarantees, and we're going to receive $3.2 million in broadband grants. So that's broadband.
And what strings are attached to those?
They are grants through Rural Utility Service, USDA. There is a 15% match on them. There are funds to build the towers, and then to operate the service for the first 2 years. We will be providing free internet to like police departments, rural fire departments, that type of thing, which is, the rural area is the reason we got started in Connects to start with. So I feel like we're coming out with what we wanted, which is the ability to help some of our communities get some rural broadband.
Yes.
That was not even close to the proposal when we were looking at it. That was not the purpose. I differ with you. The purpose was we were going to make money on the towers, and the other would be gravy. And we loaned them $4 million. They're only going to pay us $2 million. I don't see how you're getting out that we didn't lose $2 million. And those grants, we've got to spend that money. It's not like money coming back to the nation, and we've got to put 15% with it. And if it loses more money after the grants, then we just lost that much more. So I really don't appreciate you sitting here saying that's all we were really trying to do anyway, because that was not what you were saying when the proposal was before us.
With all due respect, Councilman Baker, I have gone back and reviewed the minutes of the exec and finance meetings when this was discussed.
Madam Chairman,
Yes.
please. I'm talking about at the CNB board meetings and the CNE board meetings that were open deals where you were making the proposals and you had the owners and how good and great and how much money we're going to make and how this was going to be the most wonderful thing since sliced bread. Now, let's be honest.
What I was getting ready to say is I was not at the exec and finance meeting when this was presented, and I wasn't at any of those board meetings early on. I started working at CNB middle of May '05, but yes, this was presented as a business investment, but I do remember, at least from the minutes of the ENF meeting, that
one of the positive aspects to this was the ability to go out and try to provide broadband internet service to some of our rural areas. The business side of it, as I reported many times, the Tulsa network, the customers weren't there. And we ceased funding this operation in October of '05. Our minority partners continued to fund it up until August of '06, including they made a couple of principal payments on the loans and paid the interest. Shortly after that, they didn't make a interest payment. We sent them a notice of default, and we did a workout arrangement to get out of the business side of it. So.
Sorry, you through?
No.
Okay, and then David.
So, do you think it was a good deal for the Cherokee people to spend $2 million to get $3.something million in grants? Was that a good investment? And did it create any jobs?
It has not created any jobs yet, and as far as deciding what's a good investment, $1 million profit would be nice on $2 million. So, if you look at it from a pure business standpoint, if you invest $2 million and get $3 million back, yeah, that's a positive thing.
We didn't have to do it to get those rural development grants.
I didn't say that we had to do that.
We didn't have to pay $4 million to apply for those rural development grants. We could have done it and not even done Cherokee Connect.
And I can't answer that because I don't know whether we had the internal technical knowledge to do that.
So as a CPA, how much have we lost on this deal?
Well, if you look at our financial statements, you can see that Cherokee Connect's lost right at $1 million the first year and $900,000 the second year. And this is all fully disclosed in the financial statements that were delivered in our annual report.
And that'd be an extra $1 million if they don't make the last payment.
That's Doug.
Is that right, Doug? If they don't make the last payment.
First payment was $400.
So there's 1.6 balance.
1550.
Oh, the last, there wasn't half and half.
No.
But I'm not, are you saying that the grant would allow us to pay ourselves back?
No. I'm just, he was hypothetically saying getting $3 million for $2, was that a good deal? And I said, in a business world, if I invest $2 million and get back $3, then that's a positive thing.
I just didn't want you thinking, I mean,
I
didn't want you thinking that we can take 2 of the 3.2
No.
grant and pay ourselves back.
No. We got to build towers and give services and...
I thought we got out of the business.
Apparently not.
We were told 2 or 3 times we were out of the business, and all
We are out
back
of the
in it.
business. Todd Inlow's group is going to be administering those grants. Todd's group is a lot more familiar with the broadband technology than obviously I am.
We've been told it went belly up about 3 different times, then somebody breathed a sigh of relief to it. I don't really know what money we've been out month to month on it. I don't know that that's really a total amount. Doug, do you have any information on that?
I would agree with Kelly that we're right at just slightly below $2 million out on it. Now there's still this collectability of the 1.6 balance. So if we never received any more, there'd be 3.6. But assuming we're going to collect that remaining balance from the minority partner, then $2 million would be the limit of the loss.
We were also told it put a lot of Cherokee people to work, and I haven't seen anybody that's put it to work. I don't know who's getting the money month-to-month operation, or if there's any money there to be taken in the month-to-month operation. But we knew that going into this in Cherokee Connect, some of us were skeptical about it because we knew that we were competing against Cox and SBC. those are major. They got all kind of vehicles on the road and supplying those services. And this has kind of been a defunct thing from the get-go with the partners that we really, this council hasn't had any contact with, so to speak. And this is something that has got suddenly a breath of life, and now we're going to take off and we're going to be wonderful in this. I hope we are. I hope we're successful. But we're very skeptical about this situation with Cherokee Connect. And I think what this council is saying, we're going to keep a close eye on.
And I appreciate that, and just to be clear, we no longer own Cherokee Connects. The rural broadband grants will be administered through the nation's information systems group. The only thing that's out there remaining with Cherokee Connects is the note payment, which will be due no later than July 31st.
What's that amount?
It's $1,550,000. And we have a lot of collateral securing that.
Yes.
I just had a question. Will we be utilizing the, did you say Connect America?
Connect USA.
USA Connect.
Will we be utilizing Connect USA as a service provider through the $3.something million grant?
I can't answer that, but it's doubtful because these are more this direction. One's in Hulbert, one's in Vian. I can never remember where all 5 of them are, but Todd Enlow is going to put out an RFP on that. When he and I talked briefly about this, his idea was he was going to get, the first tower would tie into like an SBC fiber, and then that tower would shoot to the next tower. So at this point, I don't think there's any plan at all to connect in with the Tulsa ring.
Are you comfortable that they displayed payability for the remaining part of that loan?
Yes, based on the appraisals and the collateral that we have on that.
So you're prepared to instigate foreclosure on that collateral? Or
most definitely.
Okay.
That payment isn't received, and the fact that we got our March 7th payment right on time, I feel a lot better about it.
Any other questions? David?
I want to know more about the rural development grants, who they're going to, what they consist of, what they're going to do.
What they consist of are funds to build a tower and to also pay for the equipment that you need on the tower to do the broadband. I'm not real familiar with them, but I know that part of the grant agreement is that you provide free broadband to public entities such as libraries, police departments, fire departments for 2 years. And at the same time, one of the positive aspects of the grant is you're allowed to offer broadband to customers and actually charge for it. So there are 2 components. One's a public service. One is...
And then the towers are going to be owned by the Cherokee Nation or the city.
They would be owned by Cherokee Nation, yes.
And they would benefit off of this towers.
Cherokee Nation, the government?
Cherokee Nation.
It's possible. In some of our more remote office areas, I think it would be possible that we could utilize that broadband.
Would Connects benefit off of these towers?
No.
No. Well, what if Connects dissolved, then what good would those towers be?
Oh, these rural broadband towers are not affiliated with Connects.
Thank you.
Any other questions or comments? Anybody? Everybody, please. Thank you.
Thank you.
Next item on the agenda is Cherokee Nation Landfill ICI contract.
Are there some specific questions?
Bill John?
Are you closing in June or July?
We are not planning to close.
Okay. Doug might come up. Doug, the employee's been told you're going to close in June or July. The mayor of Tahlequah says you're going to close in July.
Our solid waste
Do you know where those rumors are? Are they rumors? Are they true?
There was a wide variety of rumors went around prior to the permit modification being approved last Monday at the EPC meeting, because trash haulers, Mr. Burrow back here from Delaware County, folks that are in the trash business, you drive out there and look, they knew it was closing, because the simple fact, we weren't in construction, there were no plans for construction, we had a permit that was ending in July, and we were obviously running out of airspace. So there were rumors. The employees got real nervous about their jobs. There was even a rumor at Cherry Tree Grocery Store that one of our haulers was going to take over and reopen the landfill. So we had a wide variety of things. We did get a modification from the EPC last Monday that allows us to go into an immediate construction program.
Who is we?
The landfill. It allowed the landfill to go into an immediate construction program.
Is that you wearing the ICI hat, or are you wearing the Cherokee Nation hat?
ICI will fund that construction. It is a joint thing because Cherokee Nation holds the permit. ICI has a contract to operate the landfill. The permit is held by the Financial Resources Group, Callie's group.
Okay. And when do we think we're going to have this master permit where ICI can pay the other $2.3 million, $2.7 million that is in the original contract that was 2 years ago?
The commission asked for submittal of a master plan permit within 6 to 9 months. And we will be on track to make that submittal to them.
How much of the existing sale is left?
The existing sale?
Mm-hmm.
There's around 90 days or so of airspace there now. We will have a construction completed to add airspace prior to that.
Have you all paid off the loan to Cherokee Nation Enterprises where we borrowed the money to build that sale, if you've only got 90 days left?
The payments are being made on that loan, and Callie may be able to address that more completely.
Well, the payments are being made by ICI.
Well, is it going to be paid off by the time the sale's full?
No, I can't remember the length of that loan, but I want to say it was a 5-year loan.
And under this temporary permit, we are collecting $1 a ton for the airspace?
$2 per ton.
I thought it was $2 after the master permit.
No, I went back and read the agreement because I heard discussion back and forth, and it was a little confusing. The one section says $1 per ton, but that's until the interim permit is approved, which was approved. After the interim permit is approved, we get $2 a ton. We've been getting $2 a ton for all of 2006 and 2007.
2006, how much money did we make?
Our net income for 2006 was a loss of $338. If you add back depreciation of $918, our operating cash flow is $580.
07?
I didn't bring 07 with me.
Okay. Okay. What was the finances before we leased it out?
In 2002, we had net income of $850,000. Unfortunately, that was also the year that we discovered some problems. In fact, the then manager of the landfill was let go. In 2003, we had a small profit of $217. In 2004, we lost.
Before or after depreciation?
Before. Let me read you the cash flow numbers. In 2002, it was 1042, and that's adding depreciation back. In 2003, it's 427. 2004 is 245. '05 is 914. Now, that includes the $300,000 down payment that we got from ICI when we signed the contract. And 2006 was 580, cash flow.
But we showed a loss.
Correct. And that's because of depreciation. Prior
If
to...
they paid the 2.7, what would it show?
If they had paid the 2.7, we would have been positive.
And we filled up, short of 90 days, $1 million sale?
1.3.
1.3. So if, in fact, they did close in July, any idea what we lost?
You're talking all kinds, if the landfill had closed in...
Well, I was told that Mr. Bain told the mayor that it was closing. Is that accurate?
I told the mayor of Tahlequah that without a permit modification, as I told several of the customers when they asked, that they might be having to find another place to take their trash. Because we cannot wait. It's not in anyone's best interest for me to just sit back and call up the city of Stillwell and say, hey, tomorrow you can't come out here. You know, that is not good business. It's good business to allow people to know, you know, Delaware County, the customers the nation has itself, such as the city of Fayetteville.
What is our obligation to the city of Fayetteville if we close in July?
200 tons of trash a day has to be disposed of.
So, and that contract's with the Cherokee Nation?
Yes, sir.
So I'm assuming under no circumstances are we going to close the landfill, whether ICI is involved or not. Would that be accurate?
That would not be my decision.
Well,
I can tell you that as of right now, I feel a whole lot better about the situation. The situation we were in, the contract was entered into, there was an interim permit that was only there for 2 years. You can't run a business with a permit that expires if it's the type of business that keeps requiring long-term investments. So, you know, the going back and forth between the nation, ICI, and the EPC, we finally have resolved a huge hurdle, and that's the agreement from the EPC that the permit is for the life of the landfill.
But your engineer said that, 6 months we can have a master plan.
Yes, and
we've been 2 years, and I assume that you could have pulled the trigger any time in that 2-year period to have 6 months for a master plan. And we've gone 2 years and almost filled up $1 million sale. You're charging. I mean, the contract with Fayetteville is $22 a ton, and we're getting $2 of it. And Stillwell's $18 a ton, and these folks every day, or how many tons are you putting in there a day?
Right around 1,200 tons a day.
1,200 tons a day, and at $18 a ton, and we're filling up our $1 million sale, and we might, if you throw depreciation into the mix, we might make $400,000 or $500,000. I mean, something's not right in all this gyration, and then threaten our cities that we're going to close it down if these commissioners don't give them an extension to the permit, and telling our employees that have been there for 18 years that you ain't going to have a job come July. I mean, something's not.
But can I address the timeline as I know it? We signed this contract July of '05. There were several conditions on the permit that was issued by EPC. One of those was filing the master plan. That was submitted to EPC in March of '06. EPC required a budget mod to hire an outside engineering firm to review this. Environmental Protection Commission.
Ours.
Ours.
Okay, Cherokee. Okay.
Cherokee. So that was submitted in March. I think it was June or July before they had the funding available to hire the outside engineer to review the document. Their engineer reviewed the document, had a lot of comments, met in September. It's been a back and forth conversation on this huge permit for the entire site. I met with Janine, who's the administrator, and Mr. Pitchlin, who owns ICI, back in January.
Owns it with who?
Mr. Pitchlin?
Who are all the owners of ICI?
I'm the sole owner of ICI. I have investors that invest project by project, but I'm the sole owner. It's a minority-owned LLC.
Are you Cherokee?
I'm Choctaw.
Choctaw. Okay.
So in January of '07, because things, were not moving as quickly as I thought they should be, and we knew the cell was filling up, we tried to come up with a solution to get the current permit amended so that construction could begin on the next cell. That's what finally got approved last Tuesday. At the same time, the complete site development is still there. It is still being worked on by our environmental group and by ICI's engineer. So that it's a dual track. We got to get this new cell constructed to keep open, but at the same time, we're going to get this master permit done.
So do we have the $2.7 million in escrow or anything?
No.
I feel that EPC meeting, had here these last couple of weeks. One thing that really did disturb me in that meeting, and it was those pictures that was passed around and came out, and there's seepage in that duct. And I don't know what all's being dumped in there. And I don't know where else that seepage, some of it's coming up, there's got to be some of it going down. And, I've got Sequoia District down there, and you know what runs downhill?
I live in that district.
So I'm really concerned about this. I don't want stuff running downhill on me, especially underground, because we've got no problem with cancer and all that type of things down in our county where it is.
If I could address your concern,
if you know the water tables, I'd sure like to know.
We do groundwater sampling quarterly. Our EPC goes out, or our Cherokee Nation's environmental group is in charge of oversight for the landfill. I feel confident that they have the technical expertise to perform that role, and to my knowledge, although there have been lots of rumors, there is nothing that has been substantiated to be an environmental problem at our landfill. In fact, one of the EPA staff out of Dallas, the U.S. EPA, complimented Doug that it was one of the best run landfills he had ever seen. So.
And just to point specific, the pictures you're talking about is a seepage of stormwater around a previously constructed dike area. It's not leachate from the trash. It's just stormwater runoff. And that is addressed in the upcoming construction program as well. So.
Tom?
Yes, I just had a question, Doug. You said you had about 90 days left on Air Station that cell. Has construction began on a new cell, and can you build a cell in 90 days?
We can build a cell in 90 days. We have a contractor all but under contract we've been negotiating with. And our engineer has been working ever since the EPC meeting on the finalized drawings to submit, has been in contact with Janine even over the weekend to make sure there's not any slowdowns in the approval process for the final documents. And we should be ready to go when the final documents are there. This contractor does work for Waste Management, Allied, national companies. They're used to being under a deadline. I'm confident of them.
Bill John?
What's the cost of a new cell?
It all depends on, the excavation required and that kind of thing. This construction project we're in right now will go past $3 million.
And that seepage underneath the clay, not a clay dam, what do they call it? Clay?
It's a dike.
Dike. You say that's all groundwater?
No, that's stormwater runoff.
I'm sorry, all stormwater runoff. You don't think any of it's...
No, there's a liner system that protects the trash from contact with groundwater. 2 feet of clay plus a synthetic liner.
So are you pretty confident that within 9 months there will be a master plan?
I am confident that there will be a very, very good master plan submitted. Now, it's kind of like talking about Washington lawyers. I can't stand here and guarantee you that what kind of time frame we're looking at to finish the final details between environmental programs, their consulting engineer, and our engineer. I'm confident we'll stay open, and we will have that plan in place.
Nelvana?
It's my question, but I just want to make sure, especially since Mario right here, that they can rest, not worry, because
I've assured Mr. Burrow that he will be able to keep on coming, and we're...
That's the thing you back on sleeping pills,
Well, I need to borrow some from somebody, because...
Yes.
Looking at the financial side of it, and I have been asked by several counselors to look at it. I'm not so sure we need to be focusing on cash flows alone during a period of contract with the ICI group. We have on our books a capital investment of $6 million. A large portion of that is site development cost on the cell that's almost full now. There's a term in accounting called for capital equipment when you go through its useful life. It's called depreciation, and if that asset should last 5 years, then you should, although you may pay for it all up front, you may recognize 1/5 of it each year as an operating expense. Well, depletion is the same way, except it's the utilization of a natural resource, and I'm looking for where when I look at the financial side of it, over 2.5 years we've lost, and I include depreciation, of $800,000 operating loss. But I'm still looking for where are we getting the return, where are we getting paid back for the money that it costs to open that cell. Now, I'm not talking about post-closure monitoring, liability, things like that. I'm talking about the cash invested. You all will recall that we went through a couple of years there where there was in excess of $1 million appropriated for site development costs. And I'm not really sure I'm seeing where, even if we get $2.7 million contract balance, if the $2 a ton now is providing a little bit over our non-depreciation expense, then I'm unclear as to how are we expecting that we're going to get all of our invested capital back in that cell when it's full. So I just want everyone to understand that, and I don't know where the other $3 million is going to come from to develop this next cell, but we have not received a return on that investment of the current cell on the books. There's a $6 million capital asset on the books of the landfill. Now, not all of that is that site development cost. Part of it's the equipment. and we're talking very expensive equipment. Close to $1 million dozers and compactors and Moxie trucks and what you got there? What's this?
That's the actual...
3.7 million is net book value of the site development. Is any of that for a new cell that would have just been authorized with this extension?
No, that is what we put into it. What I have just put here in front of Doug is the analysis of our costs that we had into the landfill versus what we're getting back on the contract. I went back to our fixed assets, and the site development plus the equipment was about $4.5 million when we entered into this contract. What we're getting in return is $3 million, about $1.3 million for the site development that was funded through C&EM alone, and ICI assumed the debt payment on this D8 dozer, which was the largest piece of equipment we have out there. So we're roughly a break even on what we had invested once we collect the rest of the $2.7 million.
Where's the other $1.5 million?
That is the site development from the old days that's not fully depreciated yet.
Is that cell full?
It is.
Well, why would we have not depleted that?
Because we were using a 10-year life, I determined.
Instead of
matching it.
Instead of percentage of utilization of the
Yes.
cell? Airspace, as I've heard?
Yep.
Well, now, what I'm looking at says that we have assets on book of $4.5 million. We have contracts in place and assumed debt of $4.694. So about a $100,000 difference.
Yeah.
I hope we can get there.
Yeah. It's the master plan is driving this, and once we get that master plan, the reason I thought having an outside contractor was a good idea is we avoid continuing to invest that money, because we've got a storied up and down history, and if we can get to the master plan, basically we'll have some nice little cash flows.
Part of the cash in for the tribe, so I don't want to get too far into accounting lingo here, but part of the money to us is a $1.3 million debt assumption. Okay, now is that a perfected document where we've relinquished our obligation, or is that only to the extent of the contract?
That is to the extent of the contract, I believe. I'd have to check with the lawyers on that one.
Is that also...
The same on the D8.
Okay. The current cell that's about full, we have an invested asset there. We've invested tribal money into that has a worth of $3.7 million. Is that correct?
Yes.
Okay.
At the date of conversion to a contract, yes.
Okay. The contract's $3 million.
Correct.
Does the contract mention anything about the debt assumption?
Yes, it does. It specifically addresses those two items, that ICI is responsible for repayment of the $1.3 million loan and the D8 Caterpillar.
Is it contingent upon obtaining the master plan?
I don't believe so, but again, I'm not a lawyer. I don't think it's contingent upon... Well, making these payments certainly isn't contingent upon a master plan, because we're currently getting those payments.
If that cell, if the Environmental Protection Commission would not have authorized an extension, what would have our... I mean, it seems to me like the EPC's holding all the cards here, because if they don't authorize a master plan, it looks like they've operated an extension one, which would allow somebody to pay $3 million more to open up another cell. My concern is we haven't gotten paid back for the first cell we invested in.
Bill John has a question.
No, and I understand that, but the EPC has been told that the contract is none of their business, that the financial side is business, and theirs is only environmental. And so they weren't even aware that there was a contract that hinged on this, or that we hadn't been paid $2.7 million. They've been sitting there operating, and these fellas are environmentalists. They want it done right, and they wanted to take as much time, I think, as necessary to get it right. They didn't realize that the tribe was on the hook for $2.7 million till they got to that point, and I don't think anybody shared it with them. And they are aware of it now, and I would have preferred that they extended the contract for the 9 months or a year, or something, rather than the life of the landfill. But that being said, they have given them a deadline, I hope, with $5,000 a day fines and such as that, if they don't get their master plan submitted. And I need to visit with them a little further. But it's, they've got an environmental job, but they're tribal members too, and I think they were pretty taken back finding out that this was being operated without meeting the financial obligations to the tribe.
Well, and I just want to be clear here. The EPC was aware of the contract between the nation and ICI, and ICI has met the terms of the contract.
Well, I don't think they realized that their master plan was holding out $2.7 million in a cash payment to the tribe.
Yes.
They were not aware of that.
Right.
Accurate?
That's correct. They had not realized that not taking immediate action on that master plan was holding up the payment.
Is there any language in the contract that puts a deadline on when the master plan would have had to been approved?
I don't believe so, but I'd have to go back and read it.
I didn't see it in there when I looked at the document. I'm just wondering, what's the triggering mechanism under this legal document that would enable us to get the remaining $3 million? Because it seems like this is an open-ended document to where if, hypothetically, a terrible thing would happen and we close the landfill, we've got about a $3.5–4 million exposure.
Oh, if we close landfill, we've got to live with it for 50 years.
Well, I'm not talking about the environmental, the long-term monitoring liability. I'm talking about
that's
cash out that is in excess of cash in.
Yeah.
And who's going to pay for the development of the next cell?
ICI.
Okay. Well, again, I go back to one thing, and that is how. I was here when this whole thing was presented to this body. My understanding was the $2 a ton was profit. The $3 million was to pay us back for our investment.
And you told us we ought to do it, that it was a sweet deal.
Well, you made him speechless. I'm impressed.
And it should be.
I was making a $3 million assumption when I said that.
You know what you do when you make an assumption.
You're right. Absolutely correct. And that's what we all believe.
I still believe when a capital asset is invested in that opens up a resource that avails it for depletion, $3 million is being consumed as that thing is full. Now, if it's almost full, that is just a legitimate expense as the salaries of the employees out there.
Sure.
And it's directly tied to a $2.7 million balance and a $1.3 million loan. That's the only way we're going to get our money back. We have to collect the rest of the contract, and that loan has to be paid in its entirety, or we're losing on that sale.
And that's my intent, to keep pushing forward and get everything that's required to EPC to get that master permit issued, because like Doug, I thought this was a good deal. I still think it's a good deal. We got over one hump, and we got to keep pushing to get over the next one, which is the master plan.
That's all. Thank you.
Todd?
In my review of this situation, I came across what I would think, which I'm pretty sure is an anomaly of our business relationship with ICI. There's a contract with the city of Fayetteville, and that contract is with the city of Fayetteville and the Cherokee Nation. I guess my question is to Doug or to anyone else, is that ICI performs that contract. We don't have our trash trucks out doing it, not the Cherokee Nation itself. If ICI were to fail to live up to that agreement or be negligent in the operation of that agreement, what, if any, liability would the Cherokee Nation have?
Well, I can talk to that in theory.
And I guess as a follow-up, do we have any other type of like relationships with any other business where the Cherokee Nation is the contract and the people?
The city of Fayetteville requested to do that, even though ICI was the company that went out and marketed and gained this business. The city of Fayetteville requested that they do the contract with Cherokee Nation. It was easier on their side to do a government-to-government contract rather than a government-to-a-third-party operator. So that's why Cherokee Nation was approached to be the contractor on this. There's a mirror contract between Cherokee Nation and ICI, which basically says we acknowledge that you're performing on this and that you agree to hold us harmless.
But, I mean, what if they don't?
If they don't, then we end up in court and get some of those good, greasy lawyers from Adair County.
From South Adair County.
We grew up like a half a mile from each other. But, yeah, we'd end up in litigation, I would guess.
Is there any, as I guess we're with CNB, is there any other like scenarios where we're the signer of the contract and other businesses are performing?
Are you talking about at the landfill?
Yeah, well, yeah, I mean, here we are, we're in a situation where the Cherokee Nation is the signature, and if you look at just the four corners of the document, it's Fayetteville and Cherokee Nation.
Right.
Is there any other like situations out there where the Cherokee Nation's doing this?
Not that I'm aware of.
I did have one comment about the Fayetteville contract. The city of Fayetteville does not hold a waiver of immunity with the Cherokee Nation. So that would impact it, and should ICI fail in that, the city would cash their $100,000 bond, and they couldn't sue the nation due to their lack of a waiver.
That may or may not be true, according to Judge Kennedy, and
Yes.
One other question. Make sure I'm understanding what we're doing on the EPC side. They've issued an extension
for life.
For life? What?
For life.
For life. There's an unlimited extension of time to obtain a master plan. I guess what my question is are they issuing that extension to ICI or to Cherokee Nation?
The conditional interim permit was issued with an expiration date of 2 years from date of issuance. That expiration date was removed. Its life of site for what is referred to as the Terracon footprint, which is like 91 acres. The master plan is for 330 acres, roughly.
The operating area is not that big.
Okay. Couple hundred acres. The EPC is permitting Cherokee Nation as the owner of the landfill and ICI as the operator. The master plan has to be completed within the next 12 months. Otherwise, you don't have a long-term viable business there, because then you're still doing one cell here, one cell here, one cell here. The EPC, even though they've issued a permit for the life of the facility, at any time, if there is an environmental question, they still have a compliance responsibility. And that was some of the discussion at the EPC meeting last week, that removing this expiration date does not dilute any of their authority for compliance with Cherokee Nation's code. So they are still responsible for ensuring on the environmental side that we comply at the landfill. On the financial side, I'm responsible for pushing and making sure that ICI gets that master permit document submitted, and that any questions that come back from the EPC or the environmental staff get answered as quickly as possible.
What do you have to enforce that? On the financial side, what do you have to promote that adherence by ICI?
The fact that we have a contract.
Is there anything in that contract, though, like I asked a while ago, what is in that contract that protects the investment of the Cherokee Nation? Because if the EPC had not done what they did last week, and we would have had to shut the landfill down, how would our $4 million investment have been recovered when the cell's full?
Well, and that's why it was so critical to get that permit modified.
So are we under any obligation to continue with ICI?
I don't know. I'm not an attorney, but I would think unless we're in breach or they're in breach, it's an ongoing contract.
So they have 12 months, or we have 12 months to get a master plan approved through EPC.
That's my goal.
Cherokee Nation.
Cherokee Nation.
Not ICI.
Well, ICI is doing the work as the contract operator. I don't know nothing about no landfills from the technical side. But we do have internal staff with environmental programs who are reviewing all this to ensure that it's being done right.
What if we don't get that approval?
I don't know. We'll be back here again in 6 years. I think this particular cell is projected to last a year and a half. So it's critical that we get this master plan approved.
So Kelly, if in this contract with ICI, say ICI goes belly up, we hope they don't, but if they did, who's responsible for cleanup?
That would be me, because I'm named on the permit. We would also go after ICI. Yeah. Let me make sure I understand. When you say cleanup, you mean environmental cleanup or closure?
Closure and
we are
cleanup.
Still contributing to the closure account based on the tonnage. That has not changed. ICI is responsible for the difference between what was in it when they took over and what the engineering report says is required.
And so we're all up to standard on everything right now as far as what's being done there and everything. And Joe, I'll get to you in just 1 second, please. I have another question. Well, go ahead, Joe.
Thank you, Madam Chair. Kelly, I think I heard a while ago that if we're financially, we're maybe break even at best.
Yeah. Well, once we get the 2.7, what I was showing Doug, I went back and I looked at our value in the equipment and the site development when ICI took over versus what we're getting in terms of the $3 million and the C&E loan and the Caterpillar D8. We're about $100,000 to the positive. Then going forward, once we get the master plan and get the 2.7, basically we're getting $2 a ton without having to invest any money into this.
Okay. Well, I'm looking at something that said the value of the contract with the City of Fayetteville should equate to about $1,184,000 to the Cherokee Nation. And does the City of Fayetteville think they're doing business with a permitted, licensed, and compliant with all federal regulations regarding environmentally sound landfill?
I can't speak to what the city of Fayetteville thinks, but I do know that that's stated in the contract that we're complying with all of our statutes.
Are our regulations and whatever with our environmental group tougher than the federal regulations are?
I can't speak to that. I think they're very similar. I don't know if they're tougher or the same.
I was just wondering if the city of Fayetteville were to get, and maybe they know about the fact that we're out of compliance down there and have been maybe since inception, but certainly since this contract with ICI.
The only compliance issue before the Cherokee Nation EPC right now is the stormwater depression, which is a condition that was in existence long before ICI took over, and a pollutant loading study, which was requested by the EPC. The stormwater depression, a temporary solution, has been approved by the EPC, which is basically pumping that water out, and that's stormwater, not leachate. And then the pollutant loading study is to be completed by the end of this month.
And one other question, do you know who Feather Hauling Services, who is that? Do you know who that is?
No, I'm not familiar with it.
And what about a bond? Do you know anything about a bond that?
Yes, I do know that ICI put up the bond related to this contract.
This says Cherokee Nation has provided a performance bond.
And we did not. ICI provided that.
Okay. I might ought to let you look at this.
Yeah, maybe so.
Okay? Thank you, Madam Chair.
Has any of the council seen a contract on that? Doug, have you seen a contract with the ICI on the landfill?
Yeah.
The original contract, have you? All right, Kara?
Thank you, Madam Chair. I'm concerned, you said that we were out of compliance. Did it say with what agency and what standards and who determined who we were out of compliance? Because that's pretty serious. So.
It's our environmental protection group.
So it's Cherokee Nation.
Cherokee Nation.
Yes.
It was two items related to, when the conditional permit was issued, there was a long laundry list of compliance issues that dated back to 2002 when we had to let the manager go on all of this. There were two open items on there. One's the stormwater depression, which I guess during the construction between one or two of the cells, there was a little bit of a depression left that collected some water. That is being addressed through, on a temporary basis, through a pumping system, and on the long term with this new cell that's getting ready to be constructed. The second item was a pollutant loading study, which has been submitted in draft form, and the final document will be there at the end of the month.
Go ahead.
Thank you. Because a lot of this stuff, so maybe you don't think you can answer this. So is this something you have staff to address, the bioassessments and those things? Or do you consult? Is this something you routinely do? Because it is part of the compliance. I think the obligation's on you, right, to show compliance and provide data.
That's correct. We have outside engineers and experts that we hire under contract to provide these services. And they've been working with the EPC. I think both on the nation's staff part and on our part, we underestimated how long it was going to take for this relationship with EPC to eventually kick out permits and approvals and analysis. The pollutant loading study was one of the early requirements on the conditional interim permit, but there were no standards provided. So we worked until really, I think it was November of 2006, a year and a half after we got into the contract, before there were ever standards really provided to us.
Excuse me, sir. Could you come forward to our microphone, please? I'm sorry. Thank you.
I'm sorry, you could talk loud enough that it doesn't matter.
And just really quick, because this isn't my area, but is this small municipal waste side, I forgot, there's an acronym that EPA refers to it as, right?
CNSL, I believe, is what they typically looked to use to describe the landfill. And Doug can really give you the better history of it, but it was actually opened in the early 80s, 83, I believe. It was opened really as a public service. It wasn't at that point intended to be a for-profit activity. It was meant to assist, as lots of governments around the country were assisting in cleaning up the dump sites all over rural America. And that was originally how it started. And then, of course, with Subtitle D requirements being put in place by the federal government, just the cost of having that landfill went up dramatically. And that's the reason why, at some point back there, the Cherokee Nation found itself having to throw money at the landfill as opposed to just operating it as a service. And so it got much more complicated, much more expensive. But yes, ma'am, to answer your question, we have an engineering firm that works under contract with us. We have operations experts outside that work under contract with us. And they advise and assist Doug and the staff at the landfill in operational issues. But our engineers and the outside environmental people are doing the work and doing this pollutant loading study.
So, and then, Doug, this may be your question, and thank you, sir. May I continue?
Thank you, yes.
So, and I have not looked, and this is my bad for not looking, but I have not FOIA'd or requested the standards. So did we promulgate, or did we accept the EPA standards, or did we go more stringent or less stringent?
That would probably be a question best suited to Janine Hale, but we promulgated a code. Cherokee Nation has a solid waste code. Council passed it into law. There have not been any rules or regulations promulgated to go with that code. And the code mirrors, and in some cases goes beyond, the federal Subtitle D regulations. For instance, in relation to scenic rivers and those type of issues, there's some water quality issues where it exceeds the federal regs, just as an example. And it is a municipal solid waste landfill. That would be the typical designation.
Thank you.
You're welcome.
Council have any questions? Any other comments?
Mr. Chair, I just have one more question, Kelly. If the theoretical break-even financially is contingent upon the rest of the $3 million and the $1.3 million loan paid off to CNE, as I see, I assume that loan.
The CNE? Again, that's a legal question. It is covered in the contract. I don't know if there's an actual assumption. I'd have to check with Justice or legal.
Since we're to break even, in theory, it's a $1.3 million swing. If it's not perfected, something happens.
Okay, thank you. Yes.
I mean, this is, we don't need to act on anything really quickly, but the council needs to decide if things are working properly or they're not. And it would be a big decision that would affect people's jobs. But you don't just, even if we stopped the landfill, I'm not proposing that, I'm just conversation, that even if you stop the landfill today, you still deal with that for many years. I mean, it doesn't just go away.
No.
So I'm not clear where this discussion's headed, and I know part of it's just fact-finding. But we need to consider what needs to happen and what the proper process, and also give the opportunity for the EPC to allow it to work. Because it's not, we don't have those environmental technical folks in place. I mean, we need them in place, and we need them functioning properly. So I hope we allow them to do whatever they're supposed to do, but I think we need to look better at our role too in how we're helping push for environmental standards and such within the tribe.
Any other comments or questions? Yes, Meredith.
Callie or Mr. Peterson, when do we expect the master plan to be completed?
At the last EPC meeting, ICI's engineer said he thought he could have it written within the next 6 months. That means submitted to EPC. My goal is to have the master permit issued no more than 12 months. That's my goal. Well, what happens is you submit all the documents, and this is a very detailed technical document. EPC reviews it, and, you go back and forth with questions. Then once they're happy with the submission, because it is a master plan, there's a 30-day notice to the public. So, it gets a little more time-consuming when you get to the master plan.
Okay, thank you.
Thank you. Council have any other questions or comments? Yes, Bill.
Madam Chair, I see it's 4 o'clock. We've got another meeting.
I've got an announcement, and then I'll entertain you. Amy. Okay, Council, Amy Briel and the Cherokee Nation benefit staff will be here tomorrow on 4/17 at 3 p.m. to meet with council members to discuss open enrollment changes. So we want to be aware of that and put that on your agenda in case you need to discuss that with Amy. I entertain 3 o'clock. I entertain motion to.
Second.
All in favor? Aye. We're adjourned. Thank you.
I'm not promoted.
Rock and load.
It's loaded.